additional members to assist the chairperson in conducting the inquiry and in her work as the chairperson and in preparing the report of the commission. Clause 1 of the terms of reference provides that the commission is appointed in order to, and I quote 1, the commission is appointed to inquire with expedition into the circumstances surrounding 1, specifically the fire at Usindiso building, situated at corner of Albert and Delva Street, Marshalltown, Johannesburg Central Business District, Region F, that caused the death of at least 77 people, including women and children, and dozen more others seriously injured and homeless. 2, generally the prevalence of buildings or immovable properties in the Johannesburg Central Business District being abandoned by the legitimate landlords or owner and taken over by criminal syndicates or other groups and leased out to and populated by tenants who do not have the means to afford other forms of housing without providing basic services such as water, electricity, refuse removal, and sanitation, and paying rates and taxes, the so-called hijacked buildings. And B, in the light of the above circumstances, make findings as to who must shoulder the liability or responsibility for the said state of affairs, deaths and injuries, and C, draw lessons from circumstances and taking account of the said investigations by the SAPS and other relevant competent authorities, make recommendations insofar as the appropriate steps that must be taken and by whom, and any other matter that the Commission considers necessary or appropriate to address any relevant matters arising in relation to this clause. The first applicant is SERI, a public interest law clinic registered in terms of the legal practice and a non-governmental organization. The second applicant is the Inner City Federation, a self-organization coalition of residents of over 40 buildings in the Johannesburg inner city. The first respondent is the surviving residents of the Usindiso building. The second respondent is the city of Johannesburg. On the 28th of October 2023, the applicants lodged an application for the recusal of Commissioner Makhubela on the basis that there is a reasonable apprehension of bias that is reasonably held against Commissioner Makhubela. Following the lodging of the application, I issued directives calling on Commissioner Makhubela and others to file a notice of intention to oppose by 1 November 2023, an answering affidavit by 3 November 2023, SERI to file its replying affidavit, if any, by 6 November 2023, SERI to file its heads of argument by no later than 9 November 2023, Commissioner Makhubela to file his heads of argument by no later than 30 November 2023, and the evidence leaders to file their heads of argument by no later than 14 November 2023. While the applicants and the evidence leader complied with the directives of 31 October 2023 as they applied to them, Commissioner Makhubela did not react to these directives directed at him, so the allegations remain unchallenged. On 2 November 2023, Norton Rose attorneys representing the surviving residents of Usindiso building recorded their support for the recusal application of Commissioner Makhubela. The evidence leader also aligns itself with the relief sought in the application. Agency. As to agency, I am satisfied that this application is urgent and that the facts set out in the papers constitute good cause for condemning non-compliance with Rule 11.1. Test for recusal. It is now settled that the test for apprehension of bias is objective and the onus of establishing it rests on the applicant. In Sarfu, the Constitutional Court, speaking on the legal test to be applied, said the following, I quote, "It follows from the aforegoing that the correct approach to this application for the recusal of members of this court is objective, and the onus of establishing it rests upon the applicant. The question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case, that is, a mind open to persuasion by the evidence and the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges to administer justice without fear or favor, and the ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds, if any, of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse himself or herself if there are reasonable grounds on the part of the litigant for apprehending that the judicial officer, for whatever reasons, was not or will not be impartial, close quotation. The judgment also highlights the fact that motives for bringing a recusal application are not to be taken lightly, while the presiding officer against whom it is brought should not consider it as a personal affront. Impartiality is the cornerstone of fair and just proceedings, both judicial and administrative. An appearance of bias impairs confidence in fair and just administrative proceedings. It is important to note that the facts relied upon must be correct. Recusal applications implicate the provisions of Section 34 of the Constitution, which dictates the right of everyone to have their disputes that can be resolved by the application of the law to be decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. The test in Sarfu has since been applied in a case involving an administrative tribunal, C. Turnbull Jackson versus Hibiscus Coast Municipality and others, 2014 ZACC 24. The facts. The facts underpinning the relief which is being sought in this application are as follows. The applicants allege that Commissioner Makubela's public statements on X, the platform formerly known as Twitter, over a period of 6 years, shows that he is closely associated with and is an active supporter of Operation Dudula and the Put South Africa First movements, which are xenophobic. For example, Commissioner Makubela has either posted, reposted, commented on, and liked on his social media platform the following utterances. I quote, "Commander's morning, being nice and respectful is not giving us results. It is time for accelerated programs around illegal foreigners. SA politicians who prioritize illegal foreigners over South Africans can also start packing. We will win this war," close quotation. Next, I quote, "You won't find South Africans in other countries dominating a city up to 80%. We cannot surrender our country to foreign nationals. Hashtag Operation Dudula," close quote. Next quote, "We are expected by so-called human rights lawyers to witness this blatant lawlessness happen in our city," close quotation. Next quote, will only provide accommodation to South Africans, close quotation. Commissioner Makubela's ex-biography contains texts such as, I quote, "South Africa for South Africans first." In no specific order, there were tweets by the Commissioner as well as reposted tweets and tweets by third parties, which have been liked and reposted by the Commissioner, which are in support of Operation Dudula, as well as including the hashtags Operation Dudula and hashtag Put South Africa First. A few of such posts reads, A, I quote, "We've allowed someone else to tell us that we are xenophobic, and now many of us believe it. We've let them tell us what our problems are and what to do to solve them," close quotation. B, I quote, "South Africans are unemployed because of illegal foreigners," close quotation. C, I quote, "Please can the rumored coup in Zim be successful so that Zimbabweans can leave, go back home to rebuild their country," close quotation. D, I quote, "Attacks on illegal foreigners won't stop until government stops the takeover of towns and townships by foreigners. Government keeps wishing the problem away," close quotation. E, I quote, "Free Hillbrow from foreign criminals," close quotation. F, I quote, hashtag Put South Africa First. Finally, an ANC leader who acknowledges the problem rather than hide behind the stupid party line that is xenophobia. Illegal foreigners are doing as they please in this country, and the ANC was until now scared of saying it like it is, close quotation. G, I quote, Operation Dudula, hashtag Put South Africa First. Diepsloot, a dear friend of mine called Willie was gunned down by Zimbabweans in Diepsloot last week. He came home a bit late that day and walked into them breaking into his house, close quotation. H, I quote, hashtag Put South Africa First, hashtag Zimbabweans at Presidency ZA. This is an opportunity to put the rule of law first. South Africans are unemployed because of illegal foreigners. Minister Motsoaledi is the first to ever attempt to deal with this matter, close quotation. I, what this government is doing to Nhlanhla Lux is deplorable, close quotation. J, so the congregates of some church in Hillbrow assault a JMP officer. First, it was Nigerians assaulting an SAPS officer. Now it's churchgoers. Yeah, ne, close quotation. K, I quote, the deputy minister doesn't have to amend or apologize for the statement that he made on Friday. Hillbrow has been taken over by foreigners, close quotation. L, I quote, please ask the minister what the percentage of foreigners versus local inmates is in our prison. That will give you a picture of how illegal foreigners are a problem in this country. M, I quote, I fully agree with you, bro. This can't be our problem. My ANC knows this, but it boggles me why they would choose illegal foreigners at the expense of South Africans. I was born and raised in Tembisa. Our relatives are unemployed due to these illegal foreigners. And I quote, and Nhlanhla Lux posted on 8 April 2022, I quote, South Africans fighting back against illegal foreigners in South Africa. Foreigners actually killing us with drugs, illegal cigarettes, human trafficking, fraud, informal settlement, stealing cables, hijacking buildings, filling up hospitals and prisons. O, Commissioner Makubela responded on 9 April 2022, and I quote, irony of ironies, I say, South Africans never enjoyed their freedom. As soon as we attained freedom, we opened our borders and all hell broke loose. Immigration issues are going to decide the 2024 elections. P. Commissioner Makubela retweeted a poster of an Operation Dudula poster image. The poster contains an Operation Dudula name and icon. It contains the following text, I quote, "South Africa for South Africans first," close quotation. The text in the poster refers to a Pimville launch dated 23 January 2022 and provides a venue. The poster has the agenda stated as illegal immigrants. And the text thereafter reads, I quote, "We are tired. Enough is enough. South Africa citizens first now. Mabahambe." And followed by the Operation Dudula icon. The text of the tweet reads as follows, "You better go even. The at EFF South Africa is turning back on you. Futek EFF," close quotation. Almost all of his posts since 2017 relate to foreign nationals, especially those living in Johannesburg. His pinned post reads as follows, and I quote, "Attacks on illegal foreigners won't stop until government stops the takeover of towns and township by foreigners. Government keeps wishing the problem away." Between the period 2017 to 2022, he posted and reposted content that is related to foreign nationals, often criticizing the government for not addressing the issues he deemed to be associated with foreign nationals. The surviving residents of Usindiso have also filed affidavits in support of the application for the recusal. They all hold a view that the findings of the Commission may be impacted in a manner that is not fair or impartial as a result of Commissioner Makubela's participation in the Commission. I advert to a few of these individuals. For instance, Mr. Ramadan is a Kenyan citizen who previously resided at Usindiso building. Prior to the fire, he has been a victim of the illegal raids conducted by members of Operation Dudula and was assaulted and robbed by these members. On the morning of the fire, he witnessed members of Operation Dudula carrying weapons and singing songs to celebrate the fire. Mr. Muyiza is a Tanzanian citizen who holds an opinion that Operation Dudula is involved in the circumstances that led to the fire. He states, and I quote, "Members of Operation Dudula came to the scene chanting and dancing in front of the building with weapons in hand. They made xenophobic remarks to the victims who were standing outside the building or helping others. We were told that we had no choice but to go back to our countries of origin because they have now burnt the building. I suspect that Operation Dudula was indeed behind the burning of the building because of such statements." He also states that I believe Commissioner Makubela would not be a fit commissioner for this inquiry because he has a xenophobic mindset. Ms. Mapule Ndaba is a long-standing resident of Usindiso building. She details an incident in 2023 where Operation Dudula attacked residents of the building. She says that Operation Dudula had, on the morning of the fire, arrived at about 6 a.m. and threatened the residents and sang in praise of the fire. She says that members of Operation Dudula told them that they had warned residents about remaining in the building. The allegations that members of Operation Dudula sang songs to celebrate the fire are supported by a media report from News 24. An extract of the article is as follows, and I quote, "As dawn broke, those who survived sat down with no hope, some missing family members, while others dealt with having watched their loved ones die. Broken, they were forced to move to the end of the street as the scene was taped off. As they stood watching in grief at what had become a recovery mission, members of Operation Dudula arrived. The vigilante organization danced as they sang that they did not care about foreigners," close quotation. The papers refer to Operation Dudula as a registered association whose stated objective is to expel foreign nationals from South Africa. Since its creation, it has been responsible for sustained unlawful activity targeting foreign nationals, including hate speech on social media, evictions from home, barring people from hospitals and clinics. The papers filed by the residents, represented by Norton Rose attorneys, also paint a picture of harassment and assault by members of Operation Dudula prior to the fire. The facts relied upon in this application are undisputed and are therefore accepted as correct. Grounds relied upon for bias. The applicants contend that Commissioner Makubela might be biased because he has deeply entrenched views about the role played by foreign nationals, both illegal and legal, in South Africa and in Johannesburg. He regards foreign nationals to be engaged in criminal activity, that they should not reside in Johannesburg, and that they have taken over parts of South Africa such as Hillbrow. They submit that the views held by Commissioner Makubela concern the role of law clinics such as SERI, whose clients include foreign nationals that reside in buildings which are situated in the inner city. They contend that his views concern the activities of entities such as the Inner City Federation that works with communities in approximately 40 buildings in the city. They further contend that his views are averse to foreign nationals and law clinics such as SERI, who are staffed by human rights lawyers. They further contend that since Operation Dudula and Put South Africa First have advocated for and carried out unlawful conduct towards foreign nationals and South Africans living with them, Commissioner Makubela's support for an association with Operation Dudula creates a reasonable apprehension that he might be biased. They argue that apprehension is that of a reasonable person in the position of the persons affected. Usindiso, having regard to Commissioner Makubela's posts, like post and reposted post, would conclude that Commissioner Makubela might be biased in that Commissioner Makubela is a vocal supporter of and otherwise associated with Operation Dudula and Put South Africa First. The residents of Usindiso have also been assaulted and victimized by members and supporters of Operation Dudula, and its staff and SERI and its staff has also been victimized by members and supporters of Operation Dudula. Both counsel for the applicants and the surviving residents submitted that Commissioner Makubela's sustained support for and association with Operation Dudula creates a reasonable apprehension of bias because the Commission's mandate relate to the conduct, rights, and interest of the residents of the Usindiso building, including foreign nationals. Evaluation. There is no ambiguity in the language of the tweets and the fact that they are associated with Operation Dudula and its purpose. I am of the view that Commissioner Makubela will not be able to adjudicate the work of the Commission fairly and impartially, as he has openly disseminated anti-foreign rhetoric in support of Operation Dudula and Put South Africa First. As the residents of Usindiso building state, Operation Dudula is a focused niche group of persons sharing sincerely held strong views about the perceived slights and suffering of South Africans at the hands of foreign nationals. The use of social media to rally and garner support is a tool that Operation Dudula is known by. In June 2029, Nhlanhla Lux founded Operation Dudula. It has, since its establishment, been responsible for attacks and intimidation of foreign nationals within the country in the form of raids and violence. It has a highly active presence on social media aimed at mobilizing members to respond to calls for action. Operation Dudula and Put South Africa First have meted out violence on the residents and foreign nationals of the Usindiso building and have made threats of violence, including sexual assaults, towards service staff. The terms of reference of the Commission include inquiring into the circumstances relating to the cause of the fire at the Usindiso building. Such circumstances will include the role ineluctably played by various stakeholders, such as the residents, some of whom are foreign nationals. Whatever role the residents are eventually found to have played will inform the Commission's findings. In this regard, it is clear that the mandate of the Commission includes the collection of evidence from the residents who are both South African citizens and foreign nationals as to who caused the fire and who must be responsible for that fire. It is noteworthy that Commissioner Makubela has for the past 6 years on social media expressed a firm view conveying enmity and antipathy towards foreign nationals in general and their undesirability in the city and the country. He also evinces support of Operation Dudula since the latter espouses xenophobic rhetoric. It is indeed so that Commissioner Makubela holds a firm view that foreign nationals are responsible for societal ills besetting the country, including rampant crime and unemployment. There is therefore a real apprehension that Commissioner Makubela will be unable to be impartial to issues where they pertain to foreign nationals due to his publicly expressed views about Operation Dudula and its xenophobic cause. On this score, I am therefore satisfied that Commissioner Makubela will not bring an impartial mind to bear on the work of the Commission, and that is a mind open to persuasion by evidence and submissions of counsel. A closer examination of the evidence of the surviving residents of Usindiso building perspicuously indicates that the fire is suspected of having been started by members of Operation Dudula. This evidence is very significant because the terms of reference of the Commission require it to inquire into the circumstances of the fire at the Usindiso building. This potentially implicates Operation Dudula in the fire. That being so, there is a real apprehension that Commissioner Makubela will be unable to be impartial to issues where they pertain to foreign nationals and Operation Dudula due to his publicly expressed views about Operation Dudula. On deeper reflection, the distinction between the matters that the Commission is engaged with in Part A of the terms of reference and those in Part B may prove in this application to be one without a difference. The so-called hijacked buildings may very well be occupied by foreign nationals as well. So by parity of reasoning, there is a self-evident confluence between issues in Part A and Part B of the terms of reference. It was considered in argument that certain allegations in the affidavit of Mr. Muyiza were mistaken. So, the overwhelming evidence of the reasonable apprehension of bias by many foreign nationals regarding Commissioner Makubela, which he deemed unnecessary to rebut, remain compelling. Furthermore, the terms of reference require the Commission to determine who should be held responsible for the death and injuries of those affected by the fire at the Usindiso building. It is common cause that a significant number of people affected by the fire at Usindiso building were foreign nationals. In my view, Commissioner Makubela's sustained support for and association with Operation Dudula, a group which is founded on xenophobic rhetoric, will not bring an impartial mind to bear on the adjudication of the issues before the Commission. Moreover, Commissioner Makubela is not a judge, and consideration which apply in favor of an assumption of impartiality for a judge cannot apply to him. It cannot be assumed that he can abuse his mind of any irrelevant personal beliefs or predispositions, as he has taken no oath of office as judges do to administer justice without fear or favor. Irregular application. There was an issue raised by Commissioner Makubela during the hearing that this application was irregular because the applicant's attorneys met with the chairperson and discussed the contents of the application prior to the lodging of the application. As the applicant's counsel was at pains to point out that there is simply no evidence that the applicant's attorneys met with the chairperson to discuss the actual contents of the application. Counsel pointed out that the applicant's attorneys met with the chairperson to apprise her of the letter they intended to deliver to the Commission, in which an application for Commissioner Makubela's recusals was foreshadowed. The chairperson, having been apprised of the intention to deliver the letter, gave an indication that she would await the delivery of the letter. Indeed, a letter was delivered to the Commission shortly after that meeting. The suggestion by Commissioner Makubela that the application is rendered irregular by reason of the meeting that the legal representatives of SERI had with the chairperson prior to the lodging of this recusal application is without merit for the following reasons. First, there is nothing irregular in the legal representatives of SERI meeting with the chairperson of the Commission of the Inquiry to, out of courtesy, apprise her of a letter they intended to deliver foreshadowing the issues that would be dealt with in the application for recusal. Second, the suggestion that the discussion with the chairperson entailed the discussion of the full details of the application is unsupported by any facts on the part of Commissioner Makubela. And I quote Advocate Makubela, I quote the transcripts. Advocate Makubela, yeah, but foreshadowing is one thing. Discussing the contents of the application you intend to bring is another, close quotation. Third, the rules of the Commission make no provision for dealing with matters preceding the lodging of the application. Fourth, had it been Commissioner Makubela's case to raise the irregularity of the application, he should have responded to the directives which I issued instead of raising it in argument. This he did not do. In any event, there is nothing irregular about the application as it was properly issued in terms of Rule 11. It is instructive that Commissioner Makubela, in the most egregious and gratuitous manner, held insults at the chairperson and the legal representatives of SERI, imputing impropriety and unethical conduct on their part. In no less than 28 number of occasions, Commissioner Makubela put to the legal practitioners in the application matters which suggested untoward behavior on the part of the chairperson and the legal representatives of SERI. The questions were ad hominem and had this totality to them. I quote the transcript, Advocate Makubela. Now, Mr. Brickhill, here is a matter that I would like you to assist me with. Would it then be reasonable for the person against whom this likely application is brought to then assume, and I just want us to agree on principles, to then assume that the discussions might have gone beyond what we are told? Would it not be reasonable? Is it unreasonable? Close quotation. No supporting facts were placed in support of those accusations, and no legal basis was offered to justify the attack. Failure to comply with Rule 11.4 of the Rules of the Commission. Commissioner Makubela also raised the issue that the application was irregular in that it did not cite Operation Dudula as a party to these proceedings, even though the applicants allege that Operation Dudula is suspected of having started the fire. It is sufficient to say that when the applicants lodged the application, they did not rely on the fact that members of Operation Dudula were suspected of having started the fire. It is the residents of Usindiso building who, in their support for the relief sought by the applicants, alleged that they suspected that members of Operation Dudula had started the fire. In any event, there is no need to cite Operation Dudula, as it has no direct or substantial interest in the relief sought, which is a recusal of Commissioner Makubela. Indeed, they may have an interest in due course of the proceedings of the Commission, and the rules of the Commission provides for procedures to be followed with regard to implicated parties. The role of the evidence leader in this application for recusal. Commissioner Makubela further questioned the role of the evidence leader in this application. It is again sufficient here to state that the role of the evidence leader in the Commission is set out in Clause 3 of Part A of the Terms of Reference, and I quote, "The Commission may choose and appoint one advocate who is a registered member of the Legal Practice Council of South Africa to act as counsel to the Commission, to assist in the inquiry, advise on matters of law and evidence, and present evidence to the Commission at its inquiry," close quotation. It is also important to highlight the provisions of Rule 11.5, which states that, and I quote, "As soon as possible after the chairperson has become aware of such an application, she must issue such direction or order as to the future conduct of the matter as she may consider appropriate." In line with this authority, and as soon as the application had been lodged, I caused to be issued directives on 31 October 2023, calling on the evidence leader to file its heads of argument in the recusal application. On 16 November 2023, I issued directives calling on the evidence leader to deliver its supplementary submissions on the issue of the decision-making process. On 16 November 2023, I issued directives calling on the parties to deliver supplementary submissions on the decision-making process regarding the recusal application. The terms of reference, the Provincial Commissions Act, and the rules of the Commission do not provide for the decision-making process for a recusal application. There are, however, significant indications that the chairperson of the Commission is ultimately the only commissioner to make the decision in a recusal application. The rules provide for certain decisions to be taken by the commission as a whole and others to be decided by the chairperson alone. The decision to be taken by the chairperson alone relate to legal issues and to the procedure and the conduct of the commission. The rules governing the proceedings of the commission and published on 17 October 2023 in terms of General Notice 1193 of 2023 provides in relevant part, and I quote General, 1, any party wishing to make any application to the Commission which is not otherwise provided for in these rules must do so at least 7-day calendar notice in writing to the Commission, but the chairperson may condone non-compliance with this notice period on good cause shown. 2, the Commission may condone non-compliance with or extend any time frame provided for in these rules on good cause shown when it is in the interest of the work of the Commission to do so. 3, wherever these rules make provision for any person to apply to the Commission or to the chairperson, the application must be a substantive application on affidavit with a notice of motion. The affidavit must, among other things, reflect the relevant facts, the order sought, and the grounds relied upon to seek that order. 4, the application must be lodged with the Secretary of the Commission, who will ensure that such application is delivered to the chairperson and to the evidence leader. The applicant in that application must cite every other person whose rights may be adversely affected by the order sought and serve a copy on him or her or it. As soon as possible, after the chairperson has become aware of such application, she must issue such direction or order as to the future conduct of the matter as she may consider appropriate, close quotation. The roles and powers of the Commission are spelled out in the terms of reference as follows. I quote, whereas Section 2(1) of the Provincial Commissions Act 1997, read with Section 127, 2E of the Constitution of the Republic of South Africa 1996, gives me the power by proclamation in the Government Gazette to appoint a Commission of Inquiry, designate any member of the Commission as the chairperson of the Commission, and therefore I, Andrek Banyas Alisufi, Premier of the Province of Gauteng, hereby in terms of Section 2, subsection 1 of the Act, read with Section 127, subsection 2E of the Constitution, establish a Commission of Inquiry. 2, appoint and designate Justice Sisi Virginia Kampepe as the member and chairperson of the Commission. Appoint and designate Advocate Thulani Makubela and Ms. Vuyelwa Matilda Mabena as additional members of the Commission to assist the chairperson in conducting the inquiry and in her work as chairperson and in preparing the report of the Commission, close quotation. The assertion that Commissioners Makubela and Mabena have no significance in the proceedings of the Commission is misplaced. It was put to Mr. Brickhill in these terms, I quote Advocate Makubela. Now here is my problem then. Why then bring an application for a recusal of someone that you deem not to be important in the bigger scheme of things in relation to the outcome of the matter that needs to be decided by this Commission? Because then it is in fact a contradiction. Your submission is that this is a person who is just sitting as an assessor, and in fact at any given point he may be overruled by the judge, and in fact he is simply there to assist on matters of fact, and in fact in the event there is absolutely no meeting of minds, the judge will prevail. So ultimately, the bias will actually be dealt with because the judge, according to the papers, would then be the one that makes the final determination. Would you agree with me with regard to that assessment, or would you differ? Ineluctably, Commissioners Mabena and Makubela are to do no more than to assist the chairperson in conducting the inquiry and in preparing the report. On the contrary, and on questions of fact, such as how the fire was started, by whom and when, and how the buildings were hijacked and by whom, these are all questions that all three commissioners are to decide jointly. But there is another significant indicator relevant to the issue whether the chairperson of the commission is ultimately the only commissioner to make the decision in a recusal application. The question whether Commissioner Makubela can, on the facts of this matter, bring an impartial mind to bear on the work of the commission is quintessentially a legal question that should be decided by the chairperson alone. On the other hand, questions of fact as to who started the fire, how it was started and in what manner, and how buildings were hijacked and by whom, are to be decided jointly by the commissioners. I have already alluded to the test as enunciated by the Constitutional Court in Sarfu when dealing with the test for the recusal of the application, and therefore do not repeat it. For these reasons, I hereby proceed to decide the application as the chairperson of the commission. Conclusion, having regard to the aforegoing, I am satisfied that a case has been made out for the recusal of Commissioner Makubela. In the premises, I rule that Commissioner Makubela is recused as a commissioner of the commission. That is the ruling. The proceedings are adjourned.